Okay, thanks for clicking there. I'm Mike Hartmann with the Giving Review, and we are going to be speaking today with Tal Fortgang of the Manhattan Institute. Uh, he, at the Manhattan Institute, is a legal policy fellow, and we'll ask him what he does related to that job. And we're going to be talking about an article of his in particular that was published by City Journal, the magazine of the Manhattan Institute. The article entitled How the White House Can Crack Down on Radical Groups Legally. Uh, and we'll get into that a little bit. But first, Tala, how long have you been at the Manhattan Institute and what are your research interests, if that's the best way to be asking that question?
Well, first of all, thanks for having me. Thanks for the opportunity to talk about this issue, which I think is growing in importance in public consciousness. I've been affiliated with the Manhattan Institute for a little over 2 years now. I did some part-time work for them, and then joined full-time in January of this year. So we're recording in mid-October. I've been full-time as a legal policy fellow now for about 9 months. And one thing I really love about the Manhattan Institute is that I have a great deal of leeway to focus on things that I think are pertinent uh, or under-discussed, but relevant to public policy and our public discourse. Recently, uh, my writing and research has focused on domestic extremism, and we'll get into some of the domestic extremism discussion as it relates to the nonprofit sector in a moment. I've also been writing quite a bit about the First Amendment and the limits to the freedom of speech, higher education and free speech, higher education and civil rights, all pressing issues, and that's not a coincidence. I'm not tethered to projects that are esoteric or dormant. I can write about things that I think need to be discussed and thought through right now. So
Yeah.
that's the bulk of my focus right now.
Well, let's try to get right to maybe clashes, tensions between extremism and speech. You properly write in your article about speech versus, I'll say, setting up a conflict there. I guess that's more than tension than speech versus deeds. Uh, is all speech everywhere always so constitutionally sacrosanct and protected that it can't be the subject of policy or any, infringement by the government at all? Or like where are we on that? Or where are you
Yeah,
on that? Yeah.
you have a smart and thoughtful audience, and they know that, of course, our Constitution has always recognized limits on the freedom of speech, and I think it's crucial from the outset to note a difference between free speech, right, the concept of unbridled expression, and the First Amendment's concept, the freedom of speech, with a definite article. The freedom of speech means something specific. It meant something specific when the First Amendment was ratified. And courts and our political culture and our tradition has recognized that it does not cover all free speech. There are uh, expressive acts or even pure expression that are not protected, that can be prosecuted by the government criminally, that can leave you liable to civil lawsuits, or are otherwise punishable or sanctionable in a perfectly constitutional manner. I mean, the classic examples of this stuff include defamation, which the United States Supreme Court rewrote our traditional defamation law in the middle of the 20th century, but nonetheless, defamation is still a cause of action that arises from someone's speech. And then, of course, there are time, place, and manner restrictions that have been upheld time and again for centuries. You cannot, you know, yell or speak into a megaphone in front of my house at 2 in the morning. It's perfectly legal for my hometown to establish ordinances that prohibit such disruptive behavior because there's more to American life than the right to express yourself. Um, Certainly, when it comes to conduct that may have an expressive component to it, there are limits on what you can do, and it's perfectly within the government's power to restrict you from expressing yourself through otherwise unlawful conduct. It's almost so basic as to be redundant, but apparently this needs to be restated that even if you are going to block a highway for expressive purposes, right, for the sake of a protest, you cannot claim the shelter of the First Amendment and say I cannot be prosecuted for the disorderly conduct of blocking a highway, just to use an example that's recurred over the last few years.
Does speech have a right to nonprofit status, or even, by the way, does speech have a constitutional right to the what I'll call the benefit of exemption or deductibility? And if it's not constitutional, should there be one statutorily, which is what's asserted now, and plausibly so? Uh,
I I
it-
I would say there's no inherent right for organizations that focus on speech to enjoy the special status that we afford to nonprofit corporations. I do think, as a matter of policy, normatively, it's a good thing that we have uh, educational institutions that are largely expressive, engaged in essentially political speech, not in the sense of electioneering, but in the sense of informing our politics, um, and that such organizations can exist outside the for-profit world. There isn't really a great business model for educational organizations that thankfully can rely on tax-deductible donations, enjoy favorable tax status, and enrich our politics. With that said, the trade-off has always been if you're going to enjoy this protected status as a nonprofit, there have to be certain transparency requirements, and you have to be scrupulous about following the law. Don't be fraudulent about your purposes and what you're doing with your money and your personnel, and do not use your status to try to whitewash or cover up criminal activity.
so related to that, you have written about civil terrorism. So I'll ask you to describe that and then put it in the context of the nonprofit status category or area. Uh, should I? And then this, I think you're going to answer. I'm already answering the question that I just asked you. So maybe I should just let you describe civil terrorism and the degree to which charges against it or suits against it would be applied to nonprofits.
Yeah, civil terrorism is a term that I coined to describe the uh, ascendant phenomenon of uh, activists often affiliated with um, nominal nonprofit groups engaging in uh, mass unlawful conduct in order to coerce or intimidate law-abiding citizens into adopting their political positions. That's a little bit abstract, so I'll be more concrete about it by giving the example of activists affiliated with various, recently it's been anti-Israel groups and broadly more anti-Western groups, blocking interstates in uh, many states, Illinois, New York, California, Washington State, um, blocking these roads, which is illegal. It's disorderly conduct, among other things. Um,
You say illegal. Is it a misdemeanor or a crime? Does that matter?
that's a great question.
Mhm.
In most states, and certainly in the states where these civil terrorists engage in civil terrorism, it is just a misdemeanor to engage in disorderly conduct. And they know that. They know they're not going to be prosecuted because it's just not worth the district attorney's time. In the one instance in which civil terrorists were prosecuted, it was in California and San Francisco, of all places. They blocked the Golden Gate Bridge, demonstrating against Israel and the United States support for Israel's war against Hamas in Gaza. They were arrested. Charges were brought against this group of 70 something protesters, which were affiliated with a nonprofit. And charges were dropped on the condition that these activists stayed out of trouble, obeyed the law for 60 days or so, right? Barely even a slap on the wrist, a tickle on the wrist. I just want to elaborate on the term civil terrorism for a second,
Yep.
just because many people seem to have a problem with the language, but I actually do think it's an apt term for what we're observing. Uh, Terrorism uh, is an act of violence for political ends. It's geared towards coercing or intimidating a civilian population into adopting a certain policy position. This is not violent terrorism in the sense of using bombs and guns. Thankfully, I'll say for now, this phenomenon is it's not. I don't want to impugn these groups unduly and say that they are the same as Al Qaeda or Hamas. God forbid, they're not. They engage in more civil tactics, but the logic is the same. The logic is we will break the laws that exist to preserve the good working order of society. We're going to break those laws so that we can inconvenience people to a point where they say, just government, elected officials, make these people go away, give them what they want. And that subverts and circumvents the political process because instead of engaging in speech that leads to persuasion, that leads to democratic outcomes where the will of the people is actually represented, this just does an entire runaround and says, we're going to make law abiding people cry uncle, and that's how we're going to get what we want. It is the logic of terrorism. It is civil, if unlawful, in its methods.
Hmm. Tell me about the case in which you have, I think, co-authored an amicus brief, which is, you would call it a civil terrorism case, I think. Uh, Manhart versus Westpac, which is a group with which Giving Review readers might be familiar. Uh, so, what's the status of that case, and does the position in the brief differ from how you've described civil terrorism?
This is really a consummate civil terrorism case. Just some basic background is that some anti-Israel activists blocked a highway as part of a coordinated national uh, demonstration effort um, on April 15th, 2024, I think is the exact date. Um, and someone who was stuck in the resulting traffic uh, missed his flight, missed important uh, business and family related items, and is suing the organizations that helped organize and participate in this unlawful demonstration for uh, the civil cause of action of false imprisonment. If you entrap someone in a place where they cannot get out and you do not have the right to entrap them, that is a tort called false imprisonment. Um, and it is this person sued the organizers, as I noted, some of which are nonprofits like Westpac. Um, he sued them for organizing this, and it's unlawful activity that unduly entrapped this person, causing him great loss. It's really exactly what civil terrorism is meant to do, make someone's life miserable, and he's hitting back. This person said, the prosecutors in Illinois are not going to hold these people accountable. It's not worth their time. The incentives just aren't properly aligned. Um, so I'm going to take this matter into my own hands and raise the cost of engaging in this kind of unlawful activity, which is what civil litigation does all the time. The lawsuit was dismissed in the Northern District of Illinois. The judge dismissed the complaint, uh, calling it essentially an effort to quell pro-Palestinian speech,
Yeah.
which is exactly the conflation that civil terrorists rely on. They want judges and regular Americans and everyone observing to say this is essentially speech, political expression. That way they can continue doing it and continue exploiting the difference between what people feel, which is like this is a crazy imposition on our lives that our highways can be blocked at any moment, that our public spaces will be vandalized, and that disorder will reign. And like apparently I'm supposed to tolerate this because it's protected speech. It's obviously not protected speech. Uh, Blocking a highway, no matter what you're saying while you block the highway, is not protected speech. And if you suffer financial losses because the highway was blocked, you should have a right to compensation. So the plaintiff is appealing that judgment from the district court in Illinois. Uh, the Manhattan Institute, my colleague Ilya Shapiro filed an amicus brief explaining that terrorism really helps illuminate the difference between unlawful expressive activity and the actual speech that the First Amendment protects.
And the plaintiff is a class, right? It's a group of people, all of whom were on the highway, I guess. And what the damages they're seeking are all financial, or did anybody suggest that the tax exempt status of Westpac should be at risk?
Well, I
Or
think that's a question that is naturally raised. I don't believe that a private plaintiff has the power to, even as a class,
yeah,
has the power to suggest such remedies. Um, it would be suggestive to public officials with the power to make such determinations that
yeah,
that might be appropriate.
yeah, okay. Civil terrorism, though, you say subverts really democracy. Okay. Does it, without suggesting any remedy, does it subvert charitable status, or should it?
I think if you're using your nonprofit status to organize unlawful activity, you are abusing the deal, the implicit deal that I talked about
Yeah.
earlier, about using your special nonprofit status for good uh, to advance the public welfare through robust and informed discussion of speech. I don't think that there's anything inherent in our nonprofit system that says that you should be able to organize crimes, even if you think that those crimes advance the public welfare in some way.
Mhm.
That seems like a pretty crazy reading uh, of our nonprofit system.
I assume, Tal, you've heard and been asked. The civil rights movement was probably, violating, breaking ordinances and misdemeanors. What's your, did you, I didn't hear any complaints then from, people. I mean, you did hear complaints, but not on this basis at that time. What's your beef with the NAACP in Alabama in the 60s, or, you know?
Yeah, I think that the two are not analogous. And again, conflating civil disobedience with civil terrorism is exactly what civil terrorists want you to do, and it is incorrect. And I'll explain uh, why. One is that for the most part, civil disobedience was meant to draw attention to the injustice of the law being violated, right? So a sit-in at a segregated lunch counter uh, would lead to a disorderly conduct charge, and then Black Americans would sit in prison for the crime of sitting in a restaurant. That appeals to the great American principles of justice and equality in a way that really brings home the message this law is unjust and ought to be changed. Contrast to blocking a highway, no one thinks that there's anything unjust about laws blocking highways or preventing vandalism, at least not for now. So that's one reason. With that said, I'm perfectly willing to admit that not all civil disobedience involved drawing attention to the injustice of certain laws. There were bridge blockings, right, tactically similar. The difference there is that those who engaged in civil disobedience did not have access to the democratic process. That was precisely what they were protesting against, was that their ability to vote was actually hampered, and they had to express their will as a cohort of American citizens by other means. No one today claims that the activists who block the Golden Gate Bridge or vandalize Columbia University's property uh, are being denied access to the democratic process and are unable to vote their will and express it that way. They're just choosing not to use those uh, lawful, wonderful means to advance their ends. They are choosing lawbreaking where lawbreaking is not the only option. They also have no interest in actually serving the time for their wrongdoing, right? This is kind of a minor point, but I think it speaks to the goals of the movement that they do not relish the opportunity to write letters from Birmingham jail, right? They would love that acclaim, but they want to do this over and over and over again until you get a change in American public policy. So they celebrate that they are intimidating Americans into not wanting to punish them. They will escalate their tactics if they're not punished. They're not going to just go away.
This may be too minor a point as well, but you kind of threw in vandalism there in a way that we hadn't been talking about. Is spray painting on a government building anything? I believe in X. Is that civil terrorism, or might it be?
I mean, it depends on the message. You can imagine just like some rowdy teenagers just spray painting a government building because they're just out spray painting buildings and they want to write their names. That's still illegal.
Yeah.
It's not civil terrorism unless it's trying to advance a political end.
Yeah. Okay.
So when I lived in Washington, D.C., and in late 2023, early 2024, every park in Washington, D.C. is a national park. I would walk to work and I would pass these national parks controlled by the federal government with statues of great American heroes vandalized with the Hamas triangle that they use to signal a target, a military target in Israel, saying Hamas is coming, right? Or, F the United States, right? Essentially political messages that would otherwise be abhorrent but protected speech, but spray painted onto federal property, uh, illegal, and for a kind of coercive, intimidating political end. Yeah, that is exactly civil terrorism. That's another form that it takes.
Yeah.